Hey folks, we're back. Today let's look at the law of contracts. The law of contracts lies at the very core of most personal and business transactions. A contract occurs whenever we buy and sell something, provide or receive services for a fee, and lots of other contexts. We're not going to go into specific details because of a lot of the items in here. Just outrageous amounts of law that happens just on any one item. So we're just going to kind of touch in the lecture on the big things, the things that are intended to be taught at this level for you. There are other classes that are devoted to this, most especially Contract Law 1 and 2 at law school. So if you really want to study contracts, by all means do so. I did very well in contract law, and I absolutely detested it. But for the most part, self-explanatory. Formation of contracts. A contract is any agreement that is enforceable in a court of law. And it requires three components: an offer, an acceptance, and then, I've seen this phrased in so many books over the years, something of value, or consideration. Some places call it a meeting of the minds. An offer and acceptance, a meeting of the minds. But realistically, something of value / consideration is probably the best and what you're going to want to know. If you fail to comply with your contractual obligation, we just said it's an enforceable item under law, you can be found in breach of it and be caused to pay some damages. So the first item, the offer. The offer is a proposal made by the offeror to another individual called the offeree. The offer can be oral or written. Once you have a valid offer, and that is a substantial body of law, there has to be an acceptance. The assent of the offeree to the offer is an acceptance. By this, the offeree agrees to the terms as stated. So if you change anything, you do not have an acceptance. You have one of three other things: revocation, rejection, or counteroffer. We'll study all three of those. More explicitly, in this case, you would either have a rejection, you said no, or a counteroffer. You countered the offer with a new offer. Acceptance can occur by verbal or written agreement, or even conduct without verbal or written acceptance. That would be important. Someone walks up to you and says, "Hey, can you mow my lawn? I'll give you $50. And you say, "Yes, for $50, I will mow your lawn." You now have a bilateral contract to mow a lawn. Someone walks up and says, "Hey, I need someone to mow my lawn. I'm looking for someone to do it. Can you do it for $50? If you can you fill out this contract here so that I know when you're going to come and all this?" And you look over the piece of paper, it says $50. You're okay with the terms of you going by and doing that on what day. You accept it by signing your name, written agreement. What happens if they walk up and say, "Hey, can you mow my lawn for $50? And you just nod your head. Don't even say anything. Don't write anything. Contract law, the law of contracts, courts of contract law, like to find a contract whenever a contract can be found. To do so otherwise would be problematic. You don't want to disprove a contract. You want to make sure you can find something, an agreement of the parties. And the standard that is used is that of a third individual observing the transaction. Can this third party, this benevolent individual, view the actions as forming a contract? And a person nodding their head in the situation can be viewed as an acceptance. And the last thing is consideration. Outside of offer and acceptance, you need to have consideration. Stated consideration is anything of value, or the agreement to do or not to do something that one is legally capable of doing. Some things that kind of formation of a contract or the enforceability of a contract into question. A condition precedent. Okay? It's an event that has to happen. It has to happen before an agreement becomes effective. So, if someone is going to sponsor you to run a race and they sign on the piece of paper, they'll give you $100 if you do the 10K. A condition precedent is that you will run in the race. So what happens if here in Miami we have a hurricane that day and the race is canceled? Or if you're in the northeastern United States, you get a nor'easter blow through. Condition precedent. Can't enforce the contract, can't ask for the money if the race didn't happen. An express contract is one in which the terms of the contract are stated by the parties either or in writing. Generally in the funeral world, when we see the words express contract, we think of a written contract, specific one, the Statement of Goods and Services that's required by the Federal Trade Commission. We'll talk about that contract much later in the course. An implied contract is one in which the terms of the contract are not stated by the parties, but their behavior shows to be a contract. This is typically associated with oral contracts. And within, implied contracts, there are two subdivisions. An implied in fact, which arises from conduct of the parties rather than their express statements. What they were doing rather than kind of what they may or may not have said. And implied in law, or quasi-contract. This is a court-imposed contract. It's where a contract, didn't exist prior, or an express contract that couldn't be enforced. And the reason why we get this quasi-contract or implied in law is because, again, we do not want people to benefit from the suffering of others. So the court has a doctrine known as the blue pencil doctrine, which allows it to edit contracts if it needs to, infer contracts if it can, and its sole purpose is to prevent unjust enrichment. A bilateral contract is a contract containing two promises, one made by each party. So with that lawnmower guy, hey, if you can mow my lawn, I'll give you $50. Hey, I'll do that. I'll go ahead and mow your lawn for $50. Promise for a promise. Bilateral. Unilateral, promise for an act, sometimes referred to as performance. So I talk about examples for these. If you walk up to someone with a laptop, I'll sell my laptop for $100. They say, I'll buy it. You have a bilateral contract. Nothing's changed hands. There's no action that's required. They said, I'd buy it. So we're going to suspend the actual contract law world and look at, except for the fact that the offer is valid here. You post a sign on a bulletin board that says laptop available for sale, $100. And the conditions, please bring $100 on this date to this place. I'm the guy in the yellow shirt. And on July 8th, you are sitting where you said you would be. Someone walks up to you, doesn't say a word, but hands you $100. You have performance. You have an action. You have a unilateral contract. Say, Professor Finn, I'm looking at this here, and it's like, well, where's the offer made? And the offer was made in the posting. Well, I've been reading my book, and it says, you have to have a defined person that's communicated to. And in this case, it's the first person. As I said, we're going to accept for the sake of argument that this was valid. First come, first served. Okay? Probably the only thing I think I needed to put in that was first come, first served. As soon as they walk up and hand you the $100, boom. So you have the offer to the first person that walks up and hands you $100. Bam, you have an offer. So what happens if we have some new medium? In this case, the internet, digital medium. Well, this created a new category of contract called an e-contract. Okay, end user licensing agreements, internet contracts, blah, blah, blah. And the law doesn't like to reinvent the wheel. You may think it does, but it does not. You will hear of a term called stare decisis. Okay, the precedent prevails. And the law does not like changing precedents very often because it throws into confusion. Lawyers need to know how kind of the law is going to act and should do things, and that's why cases have to be argued on their own merits so that it doesn't go into complete chaos. So they use traditional contract law On e-contracts, do I have an offer? Do I have an acceptance? So how do we offer it so it's communicated to a single person? How do we accept it? What do we do? So rather than reinventing things, they use the existing body of law. Now, there are courses being taught in cyber law and whatnot that specifically refer to this, but you will probably not see anything new and substantial change in the grand scheme of things. A click wrap agreement occurs when an offeree enters into a contract by clicking on a dialog box which is on a screen, such as a computer or a phone or a tablet, and is specific to an e-contract. You do not get click wraps on a physical document, or oral or implied. It has to be an electronic contract. That's where this exists. So enforceability. If you have a valid contract, everything, you have an offer, you have an acceptance, you have the consideration factor, everything's legit. Court is going to say valid contract, and it is going to enforce the terms of the contract. Whereas a void contract has no legal effect. If you were legally making DVDs and someone says, hey, I need 25, I'll give you $1,000 for them, and then you don't produce or they don't pay, the parties aren't going to end up in court arguing about this. It's a void contract. It was illegal to begin with. This type of contract cannot be enforced. So now that you're here, we're going to arrest you behind. Okay? That's sort of good. Voidable is one that can be avoided or disaffirmed or repudiated depending on the glossary you're looking at or the book you are using. Okay? A voidable contract is one that can be avoided, disaffirmed, or repudiated by one of the parties because of some rule of law that excuses that performance. Most commonly, we're going to see this in relationship to minors and mental capacity or capacity to contract. We'll talk more about that. An unenforceable contract was a perfectly valid legal contract, and then it kind of wasn't for some legal reason. Okay? Two most common places I've seen this are anything to do with statute of frauds, which we will look at, where it says this type of contract to be enforceable must be in writing. Okay? It's not an illegal contract. It's not void. All the elements were there. You just have it in the wrong medium. Or the other one is that you had a legal contract to sell something. Someone was going to buy it. It was all said and done. And then the legislative branch of the United States passes laws in both the House and the Senate now declaring the sale of whatever it is that you were selling illegal. You now have an unenforceable contract. When you entered into it, it wasn't void because it was a legal contract. Then some legal action happened. In this case, the legislative branch passed a bill which now prevented this from being sold, and the contract is essentially set aside as a result. If you have satisfied and the other person has satisfied whatever it is that you need to do in a contract, you have an executed contract. Okay? If, however, things are quote-unquote pending, it's executory. One person has yet to complete their set of duties. So with our laptop, if you posted the sign, we've indicated that that was a valid offer to first come, first serve, whoever showed up and gave you $100, and someone is walking up to you, you stand up, you walk up to them and say, you know what, deal's off, and you walk away. Well, up until the point that you revoked it, it was executory. That person was walking towards you. They're probably reaching their hand in their pocket. And something came up. Or, in a better world, that person's walking up, they take the money out, they put the money basically and wave it in your face. You take it, laptop changes. Executory. They're doing everything they needed to do, and then they tendered the payment, and away you went. You'll see how tender plays games with you later. You're going to love that. So that revocation. Remember that revocation. Person is walking up to you, they're about to get the laptop, and then you change your mind, and there's no acceptance. Okay? When you revoke the offer, it has to happen. Acceptance. If you walk up and to that guy, just mow the lawn and say, hey, for $50, can you mow my lawn? And the guy opens his mouth and says, yeah, $50, I'll do it. Consider done. You can't go back later and say, oh, you know what, that's too much money, I'm just not going to pay that, so forget I ever asked. You had a legally binding contract. So a rejection is the exact opposite. Remember the hell no. $50 to mow my lawn. Guy looks at you knowing that you have 40 acres of manicured lawn and he's under $50. He just goes, no way. Poof, done. Contract is gone. Fails for acceptance. Fails for acceptance. And a counteroffer is when the offeree rejects essentially the offer and creates a new one immediately. Doesn't he? Counteroffer. So, hey, will you mow my lawn for $50? Buddy, you know you have 40 acres. I'm not going to do it for $40. I'll do it for $2,000. And now look what's happened. The parties have shifted. The offer is now, I will mow your lawn for $2,000, yes or no, and you have to accept. The parties have reversed. So it talks about the laptop situation, okay, and how you would revoke it. What if someone got up to your face and said, nope, walked away, not going to pay $500, no tender, poof, gone, and I'm not going to pay $100, but I'll pay you $50, counteroffer. And as you can imagine, these type of little things that happen, especially when it comes to marriage, oh, it'll drive you nuts. So what about making a contract? We saw that voidable, Well, that means someone can set aside the contract because they fall into some predetermined situation or category. Instead, most often it's basically minors or mental capacity to form a contract. And the common reasons outside of the minor, okay, is mental capacity. So they are not actually capable of understanding and entering into a contractual obligation. Influence of drugs or alcohol. If a person is slurring their speech and blitzed and doesn't know if they're making the contract with you or your twin, and you do not have a twin, that could throw things into jeopardy. And a judicial declaration of insanity. A person is declared insane. It will inevitably affect their ability to enter into contracts. So with consideration, we've seen that this is important to a contract. It's represented by a Latin term you'll hear time and time again, quid pro quo, this for that. Contracts are essentially two-way streets. Promising not to do something that one has a right to do is known as a forbearance. And it is something of value, is it not? It is your time. Wait for you to wrap your mind around that. Forbearance acts as consideration, just like something of value, just like the laptop. So if you are not going to do something that you normally can and have no reason otherwise, well, you shouldn't, that is a forbearance and can be counted as consideration. With a bilateral contract, promise for a promise, we find consideration in the promises exchanged by each party. In a unilateral contract, we find it in the promise of the one and the action in the other, which means we don't actually have consideration from party number two until the act is completed. Now, doesn't that cause a problem? Because what happens if you were supposed to run a marathon for someone and then don't finish the marathon? Or build something for someone and then don't finish building it? We might have issues with consideration, which is why the law has to take into accommodation substantial performance and other items, which we will touch on. In a formal contract, back in the day, just slapping a seal on it would be consideration. So if you see something on a written document that just initials LS, that means in the Latin, locus sigilli, which means place of the seal. What about option contracts? Option contracts. It's a binding promise by an offeror. To hold an offer open requires consideration from the offeree to make it binding. You don't get it for free, essentially. Okay, you don't get it for free. So you're back, you're waiting to get paid for that laptop. Guy walks up to you, woman walks up to you, an undefined person of gender walks up to you, says, I can't pay you the $100 now. But if I give you $20 now, can you wait till next Friday or I'll pay you the extra $80? Well, that could be considered an option contract. Aren't they asking for consideration? They've given you $20. You had the right to sell it to any person that you want, and now you're forbearing that right. So, yeah, you might have something going on there. More often than not, we do this at the funeral home every time we say, I'll keep that price good for you for 30 days. Are we not giving them an offer? Must we keep it then open for 30 days? Those are items for debate and discussion. Merchants may give a firm offer. Merchant is defined by the Uniform Commercial Code. This does not require consideration as legally binding. Merchants are held to a different standard than members of the public. You operating in a funeral home capacity may be considered a merchant on a sale of goods. So what happens if consideration either isn't there or is there but not from the person you thought it would be from? Well, you run into both of these things. A lack of consideration refers to a barren promise containing no consideration in agreement. Failure of consideration refers to a contract containing consideration that was not given to the party being sued. Both are defenses in a lawsuit regarding the contract. Promissory estoppel is fun. This is something that comes into play a lot with quasi-contract, okay, or contract at law. No consideration is necessary when someone makes a promise that induces another on detrimental reliance for that promise, and injustice has to be avoided only by enforcing the promise. Lots of promises in that, right? So basically, you promise something and someone else acts on it and puts themselves at a detriment. And the only way that that person can avoid injustice is to have the original promise enforced. So the example here, person has a funeral home, nice funeral home, makes some good money. An employee says, hey, I'd love to buy this funeral home. What can I do that you'll sell me the funeral home when you're ready to retire? He says, okay, well, when I retire, I'll sell you the funeral home if you get the mortuary degree. Then you get an MBA, which requires you to get a 4-year degree, and then the graduate degree. And you relocate your family to an area local to the business. I don't want to sell my funeral to someone that lives 45 minutes away, blah, blah, blah. And the person does all this. We're looking at years of their life wasted. We're looking at thousands upon thousands of dollars spent in an education. We're looking at the severe disruption of relocating your family for the business. And then, when their owner's ready to retire, sells the business to someone else. Under the concept of promissory estoppel, the employee could enforce the original promise of selling the funeral home to them. That would be something fun to watch go through litigation, as you can imagine. And more than likely, the court's blue pencil doctrine would come into play. The court's going to find a contract in law and enforce certain items if that can actually be proven. So statute of frauds. Statute of frauds. It required that certain types of contracts needed to be in writing to prevent the occurrence of fraud. Now this harkens all the way back to the United Kingdom, Great Britain, and the English common law courts, where people would hire, quote-unquote, witnesses to testify on their behalf. And the judges, magistrates, the king, would find this to be extraordinarily problematic and travesty of justice. So one of the ways to prevent this, get it in writing. And certain contracts need to be in writing Or else we as a court, as the king, as the person in power are going to say, no contract. As Miami says, hell no. All right? So contracts that are not completed within a year, promises to answer for the debt of another, contract for the sale of an interest in real property, contracts in which marriage is the consideration or prenuptial agreement, contracts by personal representative of an estate to pay debts of the estate personally. Isn't that one interesting? Promises to leave something to someone in a will, and contracts for sale of good of 500 and more, and there are exceptions to that rule, as you can imagine. But look at the contracts by personal representative of an estate to pay debts of the estate personally. Remember we talked about corporations? Well, personal representative, when acting in their duty, is for the most part acting within the office of their appointment, which means they're not acting as John Smith, they're acting as personal representative. So when they need to do something as John Smith, there has to be a separation, because in one item, they may not be liable for their actions, in another, they might. And what happens when John Smith pays for something personally, say the funeral expenses, and then needs to lodge a claim against the estate for reimbursement, the personal representative has to pay that, even though they're one and the same. So what are the requirements of this writing? Well, memorandum is the writing that is necessary to satisfy the statute of frauds. It can be any type of writing so long as it meets the following requirements. Identifies the parties clearly. States the names or the terms of the contract. Identifies the locus or exact description of land if land is the issue. States the price. And is signed by the person against whom enforcement is sought. So understand, it's not just the person accepting. It has to be signed by both parties. Because what if the seller of the property falls through? That person would be against whom the enforcement is sought. What happens if the individual who was supposed to buy the property doesn't pony up the cash or refuses to? They need to sign, because that's against whom the enforcement is sought. And this leads into Parol Evidence. Okay? This concept, the law assumes that when a contract is reduced to writing and signed, all of its terms are contained in the writing, known as the four corners principle. What's on the contract, typewritten, is the contract and all the terms of it. Parol Evidence states that evidence of prior or contemporaneous negotiations, what you discussed before or even during, especially after, is not admissible in court to alter or contradict the terms of the written agreement. If you've reduced your contract to writing, we're only going to look to the four corners, the four corner pages, the four pages, I'm having a good time here, the four edges. If it's not contained there, what you've talked about, kind of irrelevant, except with exceptions, which we're really not going to get into. And this is important because what if one person believes they were lied to during negotiations and the contract doesn't reflect what was stated? Oh, the party making the accusation can't testify and say, hey, we talked about this. The court's going to say, but this is what the contract says. You're going to say, what? And that leads us into mistakes. So a bilateral or mutual mistake happens when both parties are mistaken about an important aspect of the agreement they entered into. This challenges the meeting of the minds or the agreement, and the contract is voidable at the option of either parties. Something in here is wrong. We were both wrong about this, and I can set it aside. So we'll say, for the sake of argument, I needed to have something made within 1/64 of an inch to be accurate to work in my machine. The other people who are going to produce this item agree 1/64 for a tolerance is exactly what you need, and whatever part they are providing will go into that. And then you get the contract and it says 1/32. You both kind of drop the ball. You both realize the error. You both realize it's a problem. Either one of you can void the contract at that point. Okay? It's a mutual mistake. But when only one party makes it a unilateral mistake, the contract cannot be avoided or be made void by the parties. You're stuck with it. You want to look it over really good before you sign it. Now, fraud occurs when one party of the contract makes a misrepresentation of material fact that the other party relies on and thereby suffers damages for it. If the defrauded party was induced by fraud to enter into the contract, it's called fraud in the inducement, and the contract is voidable at the option of the injured person. Think about what that's saying. If a person induced you by fraud to enter into a contract, you can walk away from it. Mind you, you have to prove that the fraud existed. It's not as easy as you might think it is. But you have the ability of walking from it with no harm. If you enforce it, you are going to be bound normally. Fraud in the execution is when the fraud is essential nature of the transaction. If you tell someone they're signing a birthday card, this is one of the common examples, and they are really signing a check to pay you $100, this would be fraud in the execution. Hey, can you sign this? We're passing the card around from here. Kind of on the phone, look at the computer, you just kind of look down, you sign something that says you're selling your brand new Mercedes C-Class for $50. The guy throws $50 at you and tries to grab your keys and go. That's fraud in the execution. A defrauded party always has the right to rescind or cancel the contract and to return any consideration received. Rescission restores the parties to their original positions prior to the contract. However, a defrauded party may choose to keep the consideration and affirm or approve the contract and then sue for damages. Try to get something more out of it. Okay? So what's the difference between fraud and undue influence? Well, undue influence and duress, I'm sorry. Duress, the overcoming of a person's free will by the use of unlawful threat or physical harm. So with duress, you're threatening them physically, okay? Threatening them physically or making an otherwise unlawful threat. Undue influence is the overcoming of a person's free will by misusing a position of trust and taking advantage of the other person that was relying on the trust relationship. So we talked about agency. If you are a principal, or you are a healthcare surrogate, or you are a personal representative, you may be putting undue influence anytime you overtake a person's free will and taking advantage of it. Okay? With duress, you have a bit more stress that is involved here. There was an interesting item posted on social media with the 2016 elections. And it talked about an architect that designed a ballroom for one of the candidates. And everything was approved. The business person in charge said, yes, this is great, I want it. And the architect constructed it. At time for payment, person comes, delivers the check, it's half of what was agreed upon. They go up before the person that agreed to the contract. And the business person in charge with their attorney next to them said, I'm not even going to pay that anymore. I'm going to pay even less. Take it or leave it. And the attorney says, and if you try to take this to court, my sole purpose is to keep this going so long that it's just not going to be worth it. No one's going to get anything out of it. Now, this is illustrative of duress. Duress. And the person conceded and the person said, oh, I had to, max out my credit lines and do this and do that. Well, fact of the matter is, should have gone in with an attorney to begin with so that this type of action doesn't occur, because otherwise it's just everyday political rhetoric. But if it could have been proven that duress came into this, if it could be proven even farther back that they intended to do this, it would have been fraud. Fraud in the inducement. And they would have the right to put themselves in their original position or keep the contract and sue no matter how long it takes. And if you win, you're going to get your attorney's fees back. So you can see where these type of things and looking for the right quote-unquote option is extremely important, and also the reason why you should not be entering into negotiations without an attorney. Unconscionable contracts. Some contracts are absolutely lunatic, so unfair, and benefit only one party that it shocks society, the conscience of the court. Such contracts, when it ends up in a court, will typically not be enforced. This is a hard process to prove. Boilerplate contracts with standardized language, adhesion contracts which are drawn to only one party's benefit, clauses which are used to escape legal responsibility can usually find disfavor with the court unless public policy dictates otherwise, or most importantly, both parties were on equal bargaining power. So as an example, equal bargaining power. If you have an attorney who's practiced law for 20 years, and that is what they do contracts all the time, and he, for whatever reason, with an opposing party, without attorney, is an unskilled laborer, doesn't even have a high school education, and this ends up in a court, chances are the contract would be viewed as unconscionable. And I understand I'm taking a great leap of faith here, okay? But we'll accept the facts that I presented as factually true. A lawyer, 20 years experience in an area, would certainly have much more power in a contract than a person that can barely read or write. But what if you have two attorneys arguing things out? Even if the attorney represented the unskilled laborer, okay? But for the sake of argument, it's the contract attorney versus a family law attorney in the same situation. Court might not view that as unconscionable. You both went to law school. You both took contracts one. You both knew and understand the necessity of reading a contract. You both have at least equal amount of education, JD and JD, okay? So, much less likely to be found unconscionable. So we talked about third parties and agency, did we not? That was a person that an agent contracted with for the benefit of their principal. So now we have a third-party beneficiary. Third-party beneficiary is someone who is not a party to a contract, but is benefited by a performance in the contract. Because privity of contract is generally required in order to acquire contract rights, a third-party beneficiary does not necessarily have rights under a contract. So, guy walks up to you, $50 to mow the lawn. Heck yeah, I'm going to do it for $50. This is great. And it turns out that you are mowing the lawn of his elderly grandmother. The grandmother is the third-party beneficiary. You are going to mow the lawn. The other guy provided the money. The contract is with him, and she is receiving the benefit of that contract, is she not? But she doesn't really have rights. She doesn't really have rights because she is not part of the contracting parties. So in order to have rights to sue under the contract, the third-party beneficiary must be the intended beneficiary. Was the contract made for the purpose of benefiting that individual? Incidental beneficiaries have no right to sue as they are indirectly benefited by a contract. So, back to Grandma's lawn. Intended beneficiary. She has a right to sue. He wanted to pay the money to you to mow her lawn so that she can enjoy not being harassed by the homeowners association, etc. And if she is, and she was the intended beneficiary of your actions, she is going to sue you and have some fun. However, what if the individual who paid you the $50 was selling her home and it was for his purposes that you are mowing the lawn? Not for her enjoyment, not for the HOA, not for anything other than his ability to sell her home for her. Now you have a much different situation. So assignment and delegation, these are fairly simple terms to remember and how they're applied. The transfer of a right is called an assignment. The person who has the right and is transferring it is called the assignor. The person whom the right is transferred is receiving it is called the assignee. Okay? A delegation involves duty. Rights are associated with assignments. Duty is associated with delegation. Okay? The transfer of duty is known as a delegation. Duties to perform personal services cannot be delegated without the consent of the person for whom the duties are to be performed. Basically, if you said you were going to do it, and what you do is highly specialized, that they're relying on you to do it, and you did not get permission to have someone do it for you, you had best do it, or you're going to end up in court. But the funeral home, transfer of a right, an assignment. We deal with this on pre-need contracts. Someone assigns the benefit to someone else. The right to receive the money is assigned to somebody else. With a duty, this is what happens if you need to get a funeral director, retiree, or someone that helps you out when you get busy. Instead of you taking the service out, you assign it to, or you delegate it to another funeral director. They take it out for you. It's still your firm. That would not be an issue generally, unless there was a specific reason why you needed to take that funeral out. We'll say for the sake of argument that doesn't exist. How about the situation where you contract with a completely different funeral home? You can't make it that day, so you call ABC Funeral Home down the street. They show up in their hearse with their professionals, their people, and they take the funeral. It even goes so far as to not take their signs off their fleet vehicles. Then you might run into a situation. A novation is an agreement whereby an original party to a contract is replaced by a new party, creating a completely new contract and ending the old one. When two contracting parties agree that one of them will transfer both rights and duties to a third person, and the remaining party and third person agree to deal solely with each other, privity of contract changes and novation occurs. So novation is essentially a completely new contract, but it requires a pre-existing contract. I am going to build a statue for a client. I find that as I'm advancing in years, I cannot do this any longer. So I sit down with my client and I introduce them to my apprentice who does most of the work. And they realize that even though my name was on something, this was the person that they wanted for the sake of argument. And I agree that I am going to transfer my rights and my duties, my rights to receive payment and my duty to perform the obligation, to my apprentice. The client says, great, let's do it, and I step away. Now the novation has occurred. It's a new contract between the apprentice and the client. So what are ways contracts can be discharged? 5 big ones: performance, agreement, impossibility, operation of law, and breach of contract. So performance, easy one. Everyone did what they were supposed to do. And if everyone did this, there would be considerably less law to have to learn. Okay? Under a modern doctrine of substantial performance, a contracting party can sue the other party for breach even though slight omissions or deviations were made in his or her own performance of the contract. So substantial performance opens a whole new bag of worms that we're not going to get into. So we're just going to kind of stick with it that, yeah, if you substantially perform something, okay, even if it wasn't the way it was supposed to be, identically, you may still be able to get performance in the contract. If time for performance is stated in the writing and the words time is of the essence are added, a breach of contract will occur if the contract has not been completed within those limits. So if I say I'm going to manufacture and ship something within 60 days, and I do not do it within 60 days, and we'll say for the sake of argument, I am not a merchant, or I am a merchant. And time is of the essence, and that was stated at the beginning, and they needed to have this. If I go past 60 days, I am in breach even if I ship it and they receive it on day 61. If no time for performance is put in the contract, there are no words, time is of the essence, then a reasonable time is going to be considered. And as you can imagine, that is going to be debated, and it's at the discretion of whoever it's supposed to be, the judge or the jury, which is not fun, as you can probably imagine. To be in a position to bring the suit against another for a breach, it's necessary for a party to make tender. Tender of performance means to offer to do what you have agreed to do under the terms of a contract. If you said you do it, you are still willing to do it, this is a tender of performance. Tender of payment means offer to the other party the money owed under the contract. Okay? All tender means is that you need to be in the position to do what you said you were going to do, or be able to pay what you said you were going to pay. Sometimes, when there is a dispute, instead of completing the terms of the contract, the parties will agree to set aside the original contract altogether, perform it in a completely different manner than was agreed upon. This is called an accord. So now, think for a second, how does this differ from a novation? There's one key element here that makes this different from a novation, which is almost very similar, isn't it? Two big differences. The first one is that the original parties are still the original parties. There is no introduction of a third person who gets the rights and duties assigned and delegated. Okay? The original parties are still there. And whatever the subject matter of that original contract was, it's done differently. Whereas with an novation, just the parties change. The contract and its performance do not. When that new manner of performance has been completed, this is called the satisfaction. So with an accord, person agreed to run in the Boston Marathon, and you were going to give them $100 for running in there. Got rained out. They agree that they are going to go to the state of Maine, and they're going to run a marathon up there. Well, you agree to it. They set aside the original contract. Okay, you don't have to run that thing. And if you run in that other one, I will then, pay you for that one instead. There is the accord. The person runs in the race, and you have the satisfaction. Together is how we usually hear them, an accord and satisfaction. It is essentially the replacement of an original performance with a new one, and that performance completed satisfactory. So impossibility. Contracts that are impossible to perform may be discharged by a defense called impossibility. Common causes. Death of a person who was to perform personal services. So, you are contracting a portrait. And you call the world-famous artist Barbara Salazar. She agrees to do it. She agrees on all aspects of what you want and for the price. Barbara is traveling to see her children, and while she is on the plane goes down in a river, and the artist passes away. It's impossible to get the painting because the individual that was supposed to do it is now passed on. So what about the other thing? Destruction of the exact subject matter of the contract. You agreed to purchase a painting by the world-famous artist Barbara Salazar. It is being held as part of a gallery exhibition in New York City, Soho. Fire breaks out at the gallery. Painting is destroyed. Can't do anything anymore. It's gone. And the last one, the subsequent illegality of that particular performance. We've already talked about that one. That's the one where you were going to sell some personal safety devices or something. Someone was going to buy them. Everything was good, and then Congress changed its mind about the law. Away it went. And understand that Just because something is more expensive to complete or finish than it was at the time of original contract does not guarantee impossibility as a defense. A lot of people try to get away with that. It's like, oh man, that's going to increase my cost by $1,000, $10,000. I can't do it anymore. Now, the courts kind of look at that and say, well, problem was you should have maybe considered that contingency going in. And they're going to look at it, substantial body of law and circumstances, and go, well, everyone else kind of does it and you didn't. Yeah, whatever. Operation of law. Sometimes contracts will be discharged by operation of law. Bankruptcy. If you have contracts and a firm goes bankrupt, bankruptcy is going to discharge their obligation. Statutes of limitations. You had a certain amount of time to do things, and that is now passed. And other actions of law. A breach of contract occurs when one party fails to carry out the terms of that contract. And an anticipatory breach is when the breaching party announces before the time for performance they're not going to perform. These are fun ones because in law school you get questions about unilateral contract, person running a race. Person comes back and says, hey, you know what? I'm not going to run in the race now. 50 days away. Can you sue for breach? Well, if you think about that and go back to the slide, when do the considerations happen? And see and remember that, well, hey, one consideration, the person who made the promise, that happened then. But consideration had to happen at the act. You have to ask yourself, what if they change their mind? When do I find the breach? The breach would be once the race has come and gone. So you'll see that even in law, you cannot bring a breach of contract suit until the breach is in the proper time. When it happens, whoever got injured may bring suit for damages. Nominal damages are sometimes recovered by a party who wins a lawsuit by proving that the defendant breached the contract but suffered no actual monetary loss. Nominal damages are like a penny or $1. They prove a point. Okay, they prove a point, essentially. Compensatory damages compensate the plaintiff for actual losses resulting from the breach. This generally puts the winning individual in a position they were in prior to contract. And punitive damages, the final damages, are occasionally awarded as a measure of punishment for extremely egregious acts related to the breach of contract. That is insanely rare, okay, for the most part. It's very, very rare in a contract case. It really has to be something really bad. Liquidated damages are predetermined. You anticipated something might happen. You agreed on what the damages would be at the time of the contract if the breach happened. Incidental damages may be awarded to the injured party to cover reasonable expenses that indirectly result from breach of contract. So you sue, the indirect was the cost of shipping were doubled. You win, you can get an incidental damage. And consequential damages are losses that do not flow directly from the breach but from consequent of it. So you can see that maybe incidental and consequential damages can apply to the same item depending on the situation. So if we are looking at what I just said, cover reasonable expense from indirectly resulting from contract, shipping was not one of those things that were consequential, did not actually happen as a result of the breach, but you've had to pay more for shipping because of whatever reason that entered a new season, for instance. That might be incidental. Consequential would be something probably more along the lines that after something happened, it caused you to have to ship it late. That would be a consequence of maybe someone not providing you something on time, and that caused a problem. And whenever a contract is breached, the injured party owes a duty to mitigate the damages. So if there is a problem, you just don't get to throw up the middle finger of fellowship to all parties and walk away. Okay? You actually have to take steps to make sure the damages don't go insane. Some cases, the court's going to order specific performance, which forces the party in breach to perform, since money damages or any other damage would not be an adequate remedy due to the uniqueness of the performance that was breached. This is common in sales of land. We can't just throw in another piece of land for whatever. Land is usually very unique. Ladies and gentlemen, thank you for your patience. This was a long one. Not as long as the, I believe, wills and trust. That one's going to be fun. But thank you again for your attention. We'll see you next time.